My opinion on this letter that I've just read is twofold. But firstly, let me indicate that when I was doing Juris at the University of Zululand, I did a course called Constitutional Law by Professor van der Wys Hazen. And one of the principles that pertain to this is the doctrine of separation of powers, which the French called trias politica by Montesquieu. This basic principle of constitutional law says there is a separation of powers between the executive, the legislature, and the judiciary. To hear and see a letter written by a presiding officer, and in this instance a magistrate, writing to another arm of state, the executive, in the name of the Secretary of Justice, is an affront to this doctrine of separation of powers. It is totally out of order. And secondly, being a presiding officer who is in charge of an inquest, to prejudge the matter is actually to destroy the rule of law. So in other words, my two grounds of objecting to this letter is on the basis of the separation of powers and also of subverting the cause of justice. So in other words, my conclusion is that reading from this letter is that there was no separation between presiding officers, especially magistrate, and the Department of Justice. In other words, the magistrates were an extension of the Department of Justice and, as a result, part of the state machinery to ensure the subjugation of the oppressed people.